In 1984, I was working for the law firm of Ryle and Young as a criminal defense lawyer in Eureka, just a couple of years out of law school. By then, Harold McGinnis was a perennial public defender client, having been arrested numerous times for trespassing and cutting water lines of the current property owners of property he still insisted was legally his. In his 80s, he was a chain smoker, now with COPD, sporting a scraggly beard and long gray hair, eager to tell his tale of woe, that being how his property was sold out from underneath him when he was institutionalized in the 1940s. A man evangelical in his zeal to quote selected portions of the New Testament. During jury selection for his then most recent trial for charges of trespass and assault, waving a hatchet around while he was trying to cut the water lines, he stood up and demanded that there be no women, infidels, Jews, or foreigners on the jury panel, and then attempted to go forward trying to read various New Testament excerpts about the sins that cry out to heaven for vengeance. The judge expressed a doubt as to Mr. McGinnis's mental competence to stand trial, then appointed me to represent him. In legal jargon, he was being 1368'd. Think being 86'd from a bar, except here it's not a bar, it's a courtroom. Penal Code Section 1368 being the part of the criminal code that entitles a defendant to a separate jury trial on the issue of his mental competence to even stand trial. A lawyer for a criminal defendant facing a serious felony charge, such as a homicide, might assert that their client is not mentally competent to stand trial, aiming for a state mental hospital commitment instead of perhaps a lengthy prison sentence after trial and conviction. But with Harold, these were misdemeanors. These were misdemeanor charges, ones for which the maximum penalty would be no more than 6 months or a year in county jail. The district attorney, the prosecutor, they wanted Harold found incompetent to stand trial so that he would be committed to Napa State Mental Hospital until he had, quote, recovered his competence, meaning 10 minutes after never. Were Harold found competent to stand trial, on the other hand, his sentence would be credit for time already served after his arrest, meaning he'd walk free. So I was in the position of having to prove to the jury that my man wasn't, in the conventional sense, crazy. Now, presenting Harold as mentally competent proved challenging. He never went anywhere without a nasal cannula, the plastic tubing connecting to an oxygen tank that fit into a medium-sized metal suitcase. He smoked cigarettes he rolled himself. His fingerprints were stained a deep yellowish orange. And he carried around stacks of mimeograph pages of readings from the New Testament, which he somehow thought were proving his claims to property ownership. In addition, he was fond of filing his own documents and pleadings to the court with creative titles such as Hard of Hearing. Another one was Never Have Alan Chalfie as Attorney. I decided I had no choice but to embrace him in his full eccentricity, except that he disagreed with all of my ideas about how to try the case and to show that, crazy as he appeared and sounded, he knew what he was charged with, he knew that I was his lawyer, and he was, in his way, participating in the defense. I struck a deal with Harold. If he kept his mouth shut and sat quietly while I picked the jury and cross-examined the state's witnesses, I promised that I would put him on the stand and let him tell his tale of how he'd been wronged. With that agreement, down the rabbit hole we went. While standing in the well that space between the jury and the judge on the bench, and I'm cross-examining the state's psychiatrist who has just finished testifying on direct exam that Harold was clearly incompetent to stand trial. While I'm cross-examining this expert, with my back to the counsel table, where Harold is supposed to be, remember, sitting quietly, the judge interrupted me, saying, "Mr. Crowley," I looked over, "Yes, Your Honor." "Would you please control your client?" I turned slowly around, and I saw to my horror that Harold was not sitting quietly. Harold had come around in front of the counsel table and was laying on the ground in front of the jury with the nasal cannula up to his mouth, except it was connected to nothing. Harold was huffing and puffing to something connected to nothing. Unable to contain my exasperation, I looked at Harold and said, "For God's sake, Harold, get up and sit down." When I put Harold on the stand, as promised, in answer to my first question on direct exam, which was, "Please tell the jurors where you live," Harold replied, standing up from the witness chair, "Woe unto ye lawyers, for ye are without knowledge." It's from the book of Timothy if you're scoring at home. I took a deep breath. I turned to the prosecutor and I said, "Your witness." As I walked back past his chair to my own, I leaned into him and I said, "Good luck. You're going to need it." He gave up quickly as well, unable to stem the tide of Harold's litany from the book of Revelations. All the usual suspects were included: the 7 seals, the 4 horsemen of the apocalypse, the turning of rivers into blood, numbering of the beast, Satan, 666, on and on. Figuring it was time to go for broke, I knew I had only one option for closing argument: wrap myself and Harold McGinnis in the American flag. I looked out at the jury. Ladies and gentlemen, it is not a crime in this country to be eccentric. Not yet, anyway. To disagree with your lawyer about how to conduct your defense, to not be normal. What would be a crime is to label someone as crazy who is simply different and certainly difficult. The jury returned a unanimous verdict that Harold was competent to stand trial. About a month later, I got a call from the State Public Defender's Office in Sacramento, inquiring about Harold's appeal. "Appeal?" I said. The appellate attorney said, "It looks to me like you won the case. He got credit for time served and the charges were dismissed. Why is your guy appealing?" "Isn't it obvious?" I said. "He's crazy."